Welcome to RR Corporates. If you are an insolvency professional, lawyer, creditor, or business stakeholder, this video is for you. Today, we bring you the most significant judgments from the Honorable Supreme Court and NCLT that are shaping the insolvency landscape in India. We will break down the key legal provisions, the role of Committee of Creditors, CoC, new procedural updates, and important court decisions. Before we dive in, don't forget to like, share, and subscribe to stay updated on all legal developments. Now, let's get started. Understanding the role of CoC, Committee of Creditors in CIRP. To understand the impact of these judgments, let's first discuss the role of Committee of Creditors in the Corporate Insolvency Resolution Process, CIRP. As per the Insolvency and Bankruptcy Code 2016, IBC, the CoC has the final say on approving or rejecting a resolution plan, subject to adjudicating authority approval. Here are some of key takeaways about CoC's role. Committee of Creditors, CoC has the authority to decide on crucial aspects of the CIRP. Decisions require a majority vote, 66% of major resolutions and 51% of others. Meetings of Committee of Creditors are essential and minutes must be properly recorded. Adherence to best practices ensures a transparent insolvency process. Now, let's move on to some recent Supreme Court and NCLT ruling that have significantly impacted these processes. Key Supreme Court and NCLT judgments. The latest rulings have brought significant clarity to various aspects of insolvency proceedings. Let's discuss some of the most important judgments and their implications. Supreme Court judgments Aishwarya Mohan Ghana versus Rajesh Naran. The key issues in this case is the case revolved around the venue of CoC meetings and whether a resolution professional should ensure neutrality. The appellant here is the RP conducted Committee of Creditors meeting at a financial creditor's office, leading to questions about independence. Supreme Court's decision was RPs must ensure that the meeting venue is neutral and does not raise concerns about bias. CoC meeting should be held at a location convenient for all the members. When held online, meetings must comply with video conferencing protocols to maintain fairness. The takeaway here is the ruling reinforces the need for an unbiased resolution process, ensuring that all stakeholders are treated fairly. And another case, NCLT guidelines on stakeholder consultation committee. So what is the new? Stakeholder consultation committee play a crucial role in decision making during liquidation. As per the latest August 2024 guidelines, stakeholder consultation committee meetings must follow strict procedural and voting rules. Strict procedural rules and voting rules. CoC members must maintain confidentiality during deliberations. All voting decisions must be clearly documented. Resolution professionals should maintain neutrality while facilitating discussions. So here the takeaway is ensuring transparency in stakeholder consultation committee and committee of creditors meetings is critical to maintaining trust in the insolvency process. The best practices for resolution professionals, the Insolvency and Bankruptcy Board of India has outlined best practices that all insolvency professionals must follow. These includes timely convening of CoC meetings. The first CoC meeting must be held within 7 days of CoC constitution. So within 7 days from the CoC constitution, the first CoC meeting must be held. Subsequent meetings should be held at least once every quarter. Proper documentation and notice procedures. Meeting notices should be sent 5 days in advance via email and electronic means. If urgent, the notice period can be reduced to 24 to 48 hours based on CoC approval. Ensuring confidentiality and security in meetings. Participants must confirm that no unauthorized persons are attending online meetings. All discussions should be recorded and maintained for future references. Voting and decision making. Major decisions require 66% of CoC votes, while routine matters needs 51%. So major decisions 66%, routine matters 51%. And members must inform the RP in advance if they are sending an authorized representative. So here the takeaway is strict adherence to these best practices ensures smooth insolvency proceedings and legal compliance. Key procedural updates, future outlook. Looking ahead, here are some key procedural updates that insolvency professionals and creditors must keep in mind. Updated guidelines for notice and communication. Notices must be sent via email and must include all relevant agenda documents. Emails must have proof of delivery and RPs must track email confirmations. Use of video conferencing for CoC meetings. If held online, the meeting venue is deemed to be the RP's office. Meeting links must be sent well in advance and attendance must be recorded. Increased scrutiny on resolution professionals. RPs must maintain neutrality and avoid conflicts of interest. The adjudicating authority may review CoC decision making for procedural lapses. Here, the takeaway compliance with these updates is crucial for avoiding legal complications and ensuring smooth insolvency resolution. So, the conclusion and final thought is CoC plays a crucial role in CIRP and its decisions must follow strict voting rules. The Supreme Court and National Appellate Tribunal have reinforced neutrality and procedural integrity in insolvency process. Resolution professionals must ensure compliance with updated guidelines to avoid legal scrutiny. Don't forget to like, share, and subscribe more legal updates. Don't forget to like, share, and subscribe for more legal updates. Stay tuned for our next video where we will analyze more crucial legal judgment shaping the financial sector. Thank you.